So today we'll be starting on children. There will be 2 lectures on children. That's today and Friday. And then on next Monday, it is related to children. It's on domestic violence and abduction. It will include a little bit about domestic violence against a spouse as well. But that also kind of relates to children. And then we will have 3 lectures on finance. Okay, so that's the first lecture of children. Today we'll be doing some basic concepts, the so-called welfare checklist, the factors you have to consider in doing a children case. And then I would have to go into the procedural aspect. And the next lecture I will start by doing other concepts such as custody can control. I'm sorry that I have to split up the factors and then the orders because it's really dense. So I will have to jump ahead to do procedure first, and then we start next lecture with orders, custody, can control, and access, and then we'll be doing relocation next week as well. So if you follow today's lecture and also Friday, that would pretty much cover the second and the third question of the assignment. Well, and also the last lecture on the domestic violence as well. You might want to consider that as well. Okay, so these are basically the legislations you will need for considering children issues. The second ordinance, the Guardianship of Minors Ordinance, is the all-catching legislation that governs the interest and welfare of children. Okay, the second one, the Guardianship of Minors Ordinance. So later on, I will just refer to it as GMO because it's shorter, okay? But in a divorce situation, primarily you would consider the first legislation, that's the Matrimonial Proceeding and Property Ordinance, the MPPO. Okay? So in a divorce, whether you want to consider the custody of the children or the issue of finance, both for the spouse or the children, you would consider MPPO. GMO is to fill the gap. It applies usually when the parties are not married, or when they're married but not divorcing, or for any reasons that the MPPO will not apply. Then you will go to the GMO. But primarily in a divorce is the MPPO that you will consider. GMO is to fill the gap. Okay? And you have heard of the Matrimonial Causes Ordinance, the MCO, and the subsidiary rules, the Matrimonial Causes Rules, the MCR. They concern a divorce in general. There are some parts of the MCO provides for jurisdiction for the court to make orders in relation to supervision of children or committing the children to the care of the director of the social welfare. That's also to fill the gap in the MCO. The MCR is the procedural aspect of the MCO, basically. It provides for the relevant procedure, the documents, and about drafting of the orders. Okay. For our purposes, the main focus would be the MPPO and the GMO for children. And that's usually where you would find the provisions you would rely on in making an application in matrimonial proceedings. The Parent and Child Ordinance, the PCO, in general there are 2 applications. The first is when you want to have a declaration as to parentage. What it means is that it is usually for a mother who wants to know who the biological father of the child is. And then you will seek a declaration as to parentage. Sometimes you will want to do that. Okay. The other application of the PCO, as far as I'm aware of, that is getting a little bit popular in recent years, is for surrogacy. Do you know what surrogacy means? 代母. Surrogacy. It's just for you to know. I don't think it's covered in your course manual for surrogacy. So surrogacy, it means that you have a husband and a wife, and the baby itself is carried by a third party. The third party woman is called a surrogate mother. That's the 代母. Okay? There are, from judgments, I know that there are surrogacy services, arrangements that can be made legally in the States, such as in California. There are also arrangements, I think, in India. I don't know if it's legal or illegal in India. There are also arrangements in the mainland China. I'm pretty sure in China it's illegal. But there are services, commercial services like that in China, as you will see from case law. So the embryo of that baby will be placed inside of the surrogate mother with the gametes of the husband or the wife, or both the husband and the wife. It's surrogacy, if you want to know a little bit about it. The short version of the law about surrogacy is this. Under the CPO, the legal mother of the surrogate child is the surrogate mother. It's not the wife. The legal father of the child is the surrogate mother's husband if she was married when the embryo was placed inside of her. So what would happen usually in a surrogacy arrangement is that they have the service overseas, and the surrogate mother gave birth to that child, and the husband and the wife would fly over there. For some reason, they can obtain a passport in that particular circumstances for the child, and they bring the child back to Hong Kong. But then legally, neither the husband nor the wife is the legal parent of the child. The legal parent, the legal mother, is the surrogate mother overseas. And if she was married at the time of carrying that baby, her husband provided some sort of conditions. That husband is the legal father. Okay? So in that case, that means back in Hong Kong, neither the husband nor the wife have any rights of the child. They're not the parent of the child, even though biologically they are, because it's with their gamete. So what they would have to do is to seek a parental order under the PCO. That's how PCO arises in this context. So if it is discovered throughout a matrimonial proceedings that the child is in fact a surrogate child, then very likely the proceedings will be transferred up to the High Court, and the child will be made a ward of the court, so that the court can make some orders giving the custody and the care and control to the husband and the wife, because legally they're not the parents. They don't have the rights to begin with. So you have to resort to wardship. Okay, just for you to know if you're curious about it. The adoption ordinance is obviously for adoption. Protection of Children and Juveniles Ordinance, it deals with the situation where a parent of a child, for example, commits a crime. Usually a crime against a child, such as domestic violence, or that when there's some sort of developmental issues with the child. The ordinance provides for a wide range of orders that the juvenile court can make regarding the legal guardianship, custody and control of the child, and also care and protection orders of the juveniles. And usually these rights, if under the PCJO, usually these rights will be given to the Director of Social Welfare on an interim basis. The procedure would take place at the juvenile court at the magistracy level. It's not in the family court. Okay. Just so you have some understanding of these legislations, but the main focus would be the first two, the MPPO and the GMO. So under the MPPO, a child is defined as in relation to one or both parties to a marriage includes an illegitimate or adopted child of the party, or, as the case may be, of both parties. It's very wide. It includes children born to the parties during their marriage, outside their marriage, and it can be an adopted child. But in my understanding, it does not include a surrogate child, for the reason I just said. Because I think at the time when the ordinance was enacted, surrogacy was not anticipated. It's new technology. That's why we have the CPO to fill the lacuna in the law. Okay, so in the context of MPPO, we won't think of a surrogacy situation. It doesn't seem to fit with the MPPO. Apart from the definition of a child, the more important concept is the child of the family. Okay? It means, in relation to parties to marriage, a child of both parties and any other child who has been treated by both parties as a child of their family. This definition is very, very, very important because of course I'm talking about divorce situation because we're talking about the MPPO. Under section 19 of the MPPO, which we'll cover next time, about custody, the section starts with the wording, the court may make such order as it thinks fit for the custody and education of any child of the family. So the reference is made to the child of the family, not just child. Okay. And if the child is not treated as a child of the family, then prima facie the provision is not applicable, section 19. There might be ways to resolve it by way of argument, but on the face of it, it doesn't seem to include children that are not treated as children of the family. Okay, if you go to section 19 of MPPO, then in that case, you might either have to argue or you have to resort to GMO. And child of the family is also important in terms of financial provision, because under section 5 of the MPPO, it is financial provision for child of the family in case of divorce. Again, the heading of the section is for child of the family, although it seems that it can be applicable to child of the family or any child. If you would go back to all the forms we have covered so far, the petition, statement as to arrangements for children, almost all the court documents, they refer to the concept of child of the family, not just child. It is for that reason, because in the ordinance, the provision are specifically for child of the family. Okay. So what is the child of the family? I have cited two cases here for your reference. For LNL and HPYA, the husband disputed whether the wife's son was a child of the family. So if so, then the husband would owe an obligation to maintain that child. The son was born to the wife prior to a meeting and marriage with the husband. The husband had, during the marriage, introduced the child as his son at their wedding and expressed a wish to change his name to reflect his connection with the boy in that new marriage. The test for deciding whether the child had been treated as part of the family is that the ordinary meaning of child of the family should be adopted. Okay? It is an objective test by looking at all the circumstances of the case. So you look at the facts of the case and you ask yourself, as a reasonable man, do you think that the child has been treated as a child of the family? The factors you might want to consider, the factors are where the child has lived, who has financially maintained the child, who has exercised discipline over the child, and whether the parent had claimed any of the responsibilities of a parent. So have you acted as a father, even though you're not the biological father? Did the child live with you? Did you financially maintain that child? The extent of contact between the child and his biological father since the breakdown of marriage is irrelevant. So you don't compare the relationship between the child and the biological father and the relationship between the child and the husband. You simply look at the relationship of the husband and the child. You don't compare that with the biological father. F and F is a bit, it's on its own facts. What happened is that the girl, the little girl in that family, was treated by the husband as a child of the family until at some point there were some difficulties developed between the husband and the girl. So the girl left the family and went on to live with her biological father in Canada. It was said in that judgment, it was a judgment by Justice Hartman, that as to the law, it is plain that having accepted a child into the family as a child of the marriage, it is not for a party thereafter to decide unilaterally that the child should no longer hold that position. The responsibility, once assumed, is not to be manipulated. So the first point, it says here, is that once you have seen the child as a child of family, you can't abandon that. Can't change your mind on that. Okay? Can't do away that responsibility. But in that case, the circumstances were slightly different. Because the girl had a natural father who had also discharged his obligations, and the biological father was prepared to accept the child back. And it appears from evidence that there was an agreement between the husband and the wife that the girl should return to her natural father. So in summary, a joint decisions between husband and wife have been made. It is not unilateral by the husband. And the girl was deeply at odds with the husband. And then, on the other hand, the biological father was prepared to take the girl back. So in these situations, the child should cease to be a child of that marriage and become the responsibility of her natural parents. So that would be the wife and the biological father. Okay? Is it confusing? It was a little confusing to me when I first read it. In the guardianship of minors ordinance, we don't use the term child, but instead we use minors because it's called the guardianship of minors ordinance. But the definition of minors is not provided in GMO itself. So in these situations, for the purpose of reading any legislation for your purposes, you would firstly want to go to Chapter 1. That is the Interpretation and General Clauses Ordinances. So if you don't have that definition in that particular ordinance, you would go to Chapter 1 first and see if you find anything that can help you. And under Section 3 of Chapter 1, a minor is defined as a person who has not attained the age of 18 years. There is no restriction that that minor has to be a child of a family, because it doesn't have to, the GMO doesn't have to apply in a divorce situation. It's all-catching. It's meant to be comprehensive, and it anticipates situations where the parties are not married, for example. So the concept of child in MPPO, the definition, you will see how it is interrelated to parties to marriage. Parties to marriage is a reference point. So you look at child, how is the child related to the parties to marriage. Okay? But in GMO, the reference point is simply the age of 18. On the other side, we have parents. In GMO, a parent is a father or a mother. It doesn't specify whether it is a legal father or a biological father, because naturally you don't have that separation of legal and biological parent. So I think it's only in surrogacy where you would find that distinction between legal and natural parent. Okay? And parent is also not defined in the MPPO, because MPPO concerns mainly with parties to a marriage, because it's about divorce. So you don't have that reference point of parent in relation to children. Now, in terms of guardian, it is an expression that are loosely used by the public. Okay, because we in television we always hear that reference to a 監護人, right? But usually in a family context, we actually don't refer to the concept of guardian. In law, we usually use the concept of a parent. The guardianship typically arises in a situation where a parent had died, and the surviving parent is the sole guardian of the child. Or if a parent, before he dies, has appointed a guardian in his place after his death, then that appointed guardian can act jointly with the surviving parent as joint guardians. So guardianship arises when a parent dies. Normally we don't refer to guardianship. Okay. The appointment of guardian has to be in writing. It has to be signed. It has to be attested by 2 witnesses. The appointment can be made by will. And the appointed person has to accept his office as a guardian expressly or impliedly by conduct. So when the appointing parent dies, the appointed person, assuming that he or she is willing and accepted the office, the appointed guardian would assume immediately the position of guardianship, and then he would have to apply to the court officially so that he will act jointly with the surviving parent. And in the other situation where you might encounter the term of guardianship is when, for instance, when it's necessary for the Director of Social Welfare to step in, and then the court might make an order for the Director of Social Welfare to be a guardian for the time being. Okay. So what are parental rights? In litigation, when we talk about parental rights, they usually refer to custody, care and control, and access, which we'll explore in greater length in next lecture. These are labels that encapsulate many aspects of the rights of a parent in relation to a child. The Law Reform Commission of Hong Kong, in its report on child custody and access, has summarized the parental rights as found at common law and in statute. So those rights would include the parent's right to live with the child and control the child's day-to-day upbringing. As you will see in next class, this is basically care and control. It can also include the right to the physical possession and services of the child, the right to choose the child's education, to choose the child's religion, to choose their surname. These three to five, I would say, are custodial rights. Okay. There's also the right to inflict moderate punishment on the child for discipline purposes, I suppose. The right to consent to medical treatment of the child, I think that's also custody, and the rights to enter into contracts on the child's behalf. There is also the right to act for the child in legal proceedings, the right to administer the child's property, if any, to appoint a testamentary guardian, to consent to an application for passport, arrange for leaving the jurisdiction, immigrating, consent to a child's marriage, because you can get married after 16 years old, remember? And to consent to a child's adoption. This list, you don't have to memorize it, it's just for your reference, so you know what parental rights can encompass. The list is not exhaustive, it's not conclusive, so just FYI, okay? And we'll talk about rights in the in litigation context next time. Now, there is this proposed Children's Proceedings Parental Responsibility Bill. Because throughout this course, we'll be referring to the concept of rights, custody rights, parental rights. But as proposed in this bill, there should be a shift in terminology from rights of custody to parental responsibility. The reason is this, because when we use the term rights or custody, it implies control and ownership over children as if they're properties. And also, when we have rights order, it has a taste that the parent who has the custody of the child is a winner, and the one who doesn't have, who merely has access, is a loser in a litigation over children. So the terminology really is not useful in modern societies. There are general consents amongst practitioners, social workers, and academics that the children would do better if they would spend time with both parents, when neither of the parents would feel that they have lost the children, and they're both able to have significant involvement in the children's lives. So the change in the use of that term of parental responsibility would place more emphasis on how parents discharge their duties in the interest of the children, instead of fighting for their custody. So, which theoretically would also benefit the overall well-being of the children. And the term of parental responsibility is also in line with the United Nations Convention on the Rights of the Child, to which Hong Kong is a signatory. If the bill is passed and if the parental responsibility model is adopted, then we will no longer have court order on custody, because it is assumed that both parents would have the custody, but instead the orders would focus on parental arrangements. Okay? Children arrangements in a practical sense without the label of custody and control. But this is not the law in Hong Kong yet. But on the other hand, family judges do have that mindset and mentality on focusing more on parental responsibilities rather than their rights per se. So even though we call them custodial rights, we don't like to see them as rights per se. So if the bill is passed, we don't have the rights, but at the same time, it is anticipated that there will be conflicts arising in terms of arrangement of children affair. So there will be a list of major decisions that will require notification to the other parent. There will also be a list of decisions that require express written consent of both parents, such as change of surname and immigration to another jurisdiction. Okay? And parental responsibilities would also be defined under that bill. And also because we have seen that child or minors, they are defined very differently in the GMO and in the MPBO. There are also efforts of this bill to try to consolidate everything. So we will have one concept of child or minor, whichever term you adopt. And likely, a child will simply be somebody under 18. So you don't have different ordinances and the discrepancies between the law in different contexts. Just so you know. When we talk about parental rights, there is a very important provision in the Guardianship of Minors Ordinance. It is, in fact, the most important in the GMO, and that's Section 3 of the GMO. There are a few important bits in Section 3. Under Section 3, subsection 2, subsection B, except that exception which we will talk about next, a mother shall have the same rights and authority as the law allows to a father, and the rights and the authority of the mother and father shall be equal and be exercisable by either without the other. So what it says is that if the parents of a child are married, they enjoy the same set of rights at the same degree of equal force and importance in relation to the welfare and decisions for the child. Okay. But the exception in subsection C is this: where the minor is illegitimate, a mother shall have the same rights and authority as she would have by virtue of paragraph B if the minor were legitimate. A father, on the other hand, shall only have such rights and authority, if any, as may have been ordered by a court on an application brought by the father under paragraph B. So what it means is that if the parents are unmarried, the mother would have parental rights of the child. Only the mother has the right of custody, care, and control, and the rights to make decision and care for the child. The biological father doesn't have it automatically, even though he's the biological father upon proof. So if he wants these rights, he would have to make an application under subsection C, which is on the next slide. Okay. So under subsection C, the CFI or a judge of a district court may, on application, you have to apply. You don't have it automatically for the father. Where the court is satisfied that the applicant is the father of an illegitimate child, order that the applicant shall have some or all of the rights and authority that the law will allow him as father if the minor were legitimate. The biological father, if he wants the same sort of rights as the mother, he needs to apply under subsection C with evidence to prove that he is the biological father, and then he will need to issue a separate application for custody. The reason why you want to make this application under subsection D is that you want the custody or care and control. So then you have to do two things. Okay? One is the subsection D application, and then you have to ask for custody. 2 steps. So my question is, what if the mother and the father are not married and they have a child, and subsequently the mother marries the husband? And the wife and the husband are divorcing. What would happen in this situation in relation to the child? So if the wife and the father are not married, as per subsection C, only the mother has the right for the child, right? If the father wants that same right, he has to apply under subsection D. But what about the husband of the marriage? Can he ask for custody of the child? Can he? He's not the father of the child, but he's a party to a marriage. What do you think? If, assuming he even if he has treated the child as a child of the family, can he get custody right of the child of whom he is not the biological father? Normally, it wouldn't happen, because usually for a father, if the child is not your own child, then you would just give it to you. You won't deal with that children issue in your divorce. But what if the husband has developed some bond with the child, and he also wants to care for the child, who is not his own? I don't know. Because the husband doesn't have the right to begin with. Okay. If he wants that, then I suppose he would have to resort to wardship, I think. Is it? Sorry, let me take a look. Oh, I'm so sorry. It should be subsection 1, not subsection 2. for this, this, and this. Sorry about that. So it's 31B, 31C, and 31D. Thank you. In section 4 of the GMO, there is also the principle that you can't have an agreement to give up on parental rights. An agreement for a man or woman to give up, in relation to any child of his or hers, the rights and authority referred to section 3 shall be unenforceable. So you can't have an agreement, you can't have an enforceable agreement to give up on your parental rights, except that an agreement which is to operate only during separation while married, provide for either of them to do so. But no such agreement between husband and wife shall be enforced by any court, if the court is of the opinion that it will not be for the benefit of the child. For this exception, well, the rule is this: you can't give up on being a parent. That's what it means. With the exception, I don't know what it means in practice, because it says that you can agree privately when you're married but separated. But then somebody has to look after the interest of the child. Otherwise, the court will not give force to it. Right? So effectively, you can't both give up the rights. Otherwise, the court will not enforce it. And if one party wants to give up on that parental rights, I don't think you will go to court for an order. You simply don't exercise your right. You simply disregard the child and not care for the child. I don't think you would, in reality, go ask for an order. Right? What's the purpose of it? And as you would see from this section, the emphasis is on parental responsibilities, not on rights. That's why there's effort in that bill that I told you about, to shift the whole legal concept from rights to parental responsibilities. But just a side topic, you should know that for adoption, the parents, the biological parents, can actually give consent for the child to be adopted. So effectively, they're giving up their parental rights. That's the only exception I would know. But legally speaking, they're giving consent and not giving it up. Okay, don't know how to reconcile that, but that's the rule for adoption. Okay, the best interest principle, and this time I quote the right section, 1A. So in part 2 of the GMO, it's called the general principle. There is 3.1b to d on the mother and the father rights, and then section 4 on unenforceability of parental rights. The utmost provision in part 2 or in GMO is actually section 3.1a. That is the best interest principle. It applies to basically anything about regarding children in any proceedings in the MPPO and in the GMO. So if there is one law, one principle you should know about children, that's the best interest principle. It always goes back to the best interest of the children. And as we'll see in case laws, there will usually be a list of factors and considerations. They serve as a guidance that is usually adopted and followed by the court. But at the end of the day, the only determining principle is the best interest in principle, or the welfare of the child. Okay. So the court, in any proceedings relating to the custody or upbringing of a minor or administration of their property, shall regard the best interest of the minor as the first and paramount consideration. There is no definition of what best interest is. The only hint we have is the big letter A and big letter B here, the views of the minor, any material information including the report of Director of Social Welfare. They are by no means comprehensive or exhaustive. Just two of the things that are mandated by the legislation for the court to take into account. Okay. Now, in the UK, their equivalent in legislation to our Section 3.1 is the Children Act 1989, Section 1, subsection 3. It actually provides for what we call a welfare checklist. So when the court makes an order, or varies or discharges an order in respect of the upbringing of the child, administration of his property, etc., apart from the child's welfare being the court's paramount consideration, the UK court is required by their legislation to have regard to a list of factors in subsection 3, which I set out here. So these factors would include the ascertainable wishes and feelings of the child, considered in light of his age and understanding, the child's physical, emotional, and educational needs, the likely effect on him of any change in his circumstances, his age, sex, background, and any characteristics of his which are relevant, any harm which he has suffered or at risk of suffering, how capable each of his parents is of meeting his needs. Okay, I will take you through these factors one by one. In Hong Kong, we don't have an equivalent in our statute. In the UK, from the wording, it says a court shall have regard, in particular to. So the court in the UK is required, mandated, to consider this list. But in Hong Kong, firstly, we don't have this list in our ordinance. And we have made references to this list or some of these factors, but our court is not bound by any of these factors. As said in the case of PNP by Judge Bruno Chan, who is now at the High Court, I think. Although we do not have the equivalence in our statute, I agree that most of the matters referred in the checklist, which are as follows, would be of helpful guidance and assistance to the court in the assessment of the requirement of the children's welfare. So the list is adopted as guidance, but it's not a matter of rule. It is not a law in Hong Kong. The law is best interest of the child. The list is just a guidance that helps the court in deciding what is in the best interest of the child. In practice, we might look at the list, but we don't have to rehearse each and every element in the list. Some of them might have more relevance in a particular case. It depends on that particular case. Some factors might not be applicable in some circumstances. So I also have in here another case called HNN. It says that in recent years, when applying the welfare principle under Section 3.1, judges have consistently adopted the matters specified in the welfare checklist. It has more or less become a standard practice in the family court in cases involving children to make use of the list. The High Court has endorsed this practice of referring to the welfare checklist, but there are three important things that we need to bear in mind. The first is, absent any statutory underpinning in the GMO, our courts are under no duty to have regard to the welfare checklist. In other words, it is not compulsory to do so. So whether a judge may wish to make use of it, and if so, how, is entirely a matter for him. The judge may cherry pick only those factors on the checklist which are relevant to the case before him. As long as the judge's decision is demonstrably in the best interest of the minor, he cannot be criticized for not expressly applying the checklist or not going through all the factors one by one. So it is not like, firstly, you're not bound to do so. Secondly, even if you do it, it's not like applying a formula. You don't apply it mechanically or robotically, because the discussion and determination of best interest is it's a form of art. It's not a form of science. You need to have some life experiences looking at these circumstances and consider the facts as a whole. Okay? And you don't have to rely on everything. You don't have to rehearse that list in full. And second, when applying the checklist, judges are not subject to laborious necessity of expressly relating their findings in every case to its specific provisions one by one. Otherwise, the task will become too onerous unnecessarily. This is very important because if you're in practice, you will know that when a client is not happy with a decision, they will want to find a way to appeal that decision, fighting for a second chance. And when they're really desperate, they need to find a ground of appeal. They would say that the judge has failed to consider this and consider that in the exercise of his discretion. So it says here, the judge does not have to apply that list, the factors one by one. So you can't appeal by saying that the judge has missed out one of the factors. And usually in a case, there will be 2 to 3 sticking points that stand out. And on those 2 or 3 sticking points, the case will be decided, usually, when you have special features of a case. And third, the checklist is an aide-memoire designed to ensure that none of the factors potentially relevant is left out of account. It is not meant to be exhaustive. The judges are entitled to and should indeed have regard to all other relevant factors, even though they are not on the list. So on one hand, you don't have to address every single point on the list, but on the other hand, you're free to depart from the list and consider further points that might be relevant to the particular circumstances of a case. Okay. So now I will look into the factors one by one. Can we continue? Because I appreciate it's a bit, it's conceptual at the beginning. It's a little boring and tedious. But it's necessary to lay that foundation before we go on to further things, especially for next class. do you need a break already? Or can I go on for maybe half an hour? Okay, we can continue. Okay, the wish of the child. The wish of child is actually in the statute, where it says that the court has to consider. But note the qualification. It's if it is practicable to do so considering the age and the understanding of the minor, plus the circumstances of the case. In reality, the wish of a child, usually they're not given much weight, especially when the child is very young, 3 or 4, even 7, 8, 11, 12, sort of borderline. So, but on the other hand, when a child is, say, 16, 15 years old in Hong Kong these days, considering their age and the maturity of that particular child, then the court is more likely to have regard to wishes of child of that range of age. There is this case called YNL. In that case, it involves a 9-year-old girl, and the social welfare officer, she has made a recommendation, and that recommendation was accepted by the court that the child was mature enough to voice her own feeling, but at the same time, she was sensitive and considerate not to say things that may upset either of her parent. It is very exceptional that a 9-year-old's view was accepted by the court. Usually, I would say you will have to be around 14. I think in this age in Hong Kong, I think children at the 14, 15, they're mature enough. 16, 17, it's safer, of course. They're pretty much adult, even though they're not legally. But if a child is just in primary school, I think it's difficult to give weight to a child's view. And also for the point of a wish of a child, when certain wish is expressed, there will be allegation arising with in terms of coaching and brainwashing. So what I mean is that sometimes a child might say that I want to stay with my mother, I like my mother, something like that, and that's the wish of a child expressed. And then you will have a father saying that the mother is really bad, she has been coaching and brainwashing the girl, things like that. So when there are allegations like that, the court would also be very careful in considering the wish of a child. How do we know the wish of a child? In a matrimonial case, as a matter of evidence, the child would not be a witness. The child would never be inside the courtroom in the divorce. The child would not give evidence in the court. So how do we gather evidence on the wish of a child? First is by the social investigation report. In a matrimonial case, in a divorce, whenever there is a child involved, there will inevitably be a social welfare officer who would follow through that case. Sometimes it might be 2, if that first officer has changed department or has quit. Then there will be a new officer, but there's always a social welfare officer that follows the case. So remember last time at the end when we talked about procedure, so after you petition, you might have a first appointment hearing and you might have a children's appointment hearing. Remember that? So in that first children's appointment hearing, there will be a set of directions, and that would include the court calling for a social investigation report. It would almost always happen at the first hearing. It's a standard direction. And throughout the case of the children matter, you are likely to have 2 to 3 updated reports, 2 to 3 reports in general. Because usually you would have an updated report every 9 to 12 months. Okay, so at the first hearing you will call for a report. The report will be made available in a month, 2 months' time maybe. And then if the case drags on for another year, then it's probably proper after a year's time in a hearing, the court will call for another report, an updated report, to see about the situation of the child. The social welfare officer is basically acting as the eyes and ears of the court. There's case law on this point. So the judge himself or herself would not go and investigate into the situation of the child. So he or she would delegate that job to that social welfare officer. They act as eyes and ears for the court. What you will see in a social investigation report is the basic information of the child, the age, personality, characters, the schools, the residence. There will also be the basic information of the parents of the child, what they do, where they live, how they describe the relationship with the child. The officer would call the parents, usually at the start, and then they will arrange for a face-to-face interview on one-on-one, and the officers would also conduct home visits at the respective parents' home, and then they will observe how the parents interact respectively with the child. They will also talk to the parents face-to-face as to whether they have any complaints and allegations and how they wish for the future arrangements of the children. And the officers would also interview, or at least call, other main carers of the child, such as a foreign domestic helper, if you have one, who will take care of the child. Also grandparents, possibly. They will also call the teachers of the children and see how they're doing at school, how they interact with their friends and classmates, whether there are any special learning issues, psychological issues with the child that the teachers might have observed, things like that. And then at the end, the officers would, based on these findings, make a recommendation, saying that whether the custody, care and control of the child should be given to the mother or the father, or both. The court is not bound by the recommendations. Okay, that's something you have to remember. Because the officer is merely a witness. The officer is the eyes and ears of the court to gather these information. Because as you can imagine in a divorce, what a father or a mother say in the interest of fighting for the child would be biased and self-serving. They will always claim that they're a good parent, the other one is a bad parent. Always. So the court would have to rely on the officer for something more unbiased and neutral on the facts. But then the officer is not to usurp the position of the court. So the court is not bound by the recommendations. They can consider the recommendations and adopt it, or the court doesn't have to adopt the recommendation. But in that case, the court has to give reason why they depart from the recommendation of the social welfare officer. And if a case proceeds to trial, if you really have to fight, then the social welfare officer would be a witness in that case. They are usually directed to sit through the trial and then hear evidence from the parents and other carers first, and so that in the end, usually the officer will give evidence in the end of the trial, so that having considered the evidence they have heard in courtroom, they might be able to evaluate their observations from the parents and reassess their recommendations. And sometimes, in suitable cases, the court might also direct the attendance of the social welfare officer for a CDR, That's the courtroom mediation. So the officer can also participate in that discussion as well. Okay, are we all clear on the role of a social welfare officer? The officer is not a litigant in a divorce. She's supposed to be acting as a factual witness for the court, supposed to be unbiased. The second way we can ascertain the wish of a child is by way of judicial interview. But the purpose is not to gather new evidence. It is purely for the judge to be able to listen to the child in person and to give due consideration to what they have to say. It can be initiated, the interview can be initiated by the child, if the child wants to see the judge. Or it can be initiated by the recommendation of the social welfare officer or by the party's lawyers, or it can be initiated by the judge himself. And the judge has the power to decide whether they want to interview or not. It is not automatic. In fact, judicial interview is very, very exceptional. And if the judge does decide to interview the child, he or she has to narrow down the scope and the purpose for the interview, and she has to set up the whole mechanism for that interview. And the power is used very sparingly and cautiously. I have actually assisted in a case where you have judicial interview and separate representation in one go. It's a very sad family. We act for the father. The father has some sort of anxiety, mental issue. The mother, she has OCD. She cleanses things at 3 a.m. She can't stop. She has to wash cash money from the husband's wallets continuously. She can't stop. There were 2 children in the family. The older brother, it's called Jonathan, he stopped going to school at the age of, I think, 15, something like that. And what he does daily is basically he stays in the hotel room and plays computer games every day, doesn't go to school. And we have no way of knowing how he's actually doing. There have been difficulties, even with the social welfare officer, to ascertain the actual situation of the children. As to the younger brother, his name is Jaden. Jaden, he's much younger. Jonathan was about 16, 17 at the time of trial. Jaden was about 7 or 8, something like that. He has some troubles learning as well. So what happened in that case is that the mother wants to relocate to Australia with both sons, and the father didn't want it. The father wanted the custody and care control of both children. And for the judicial interview, because there were some serious issues with the ability of the mother taking care of the children, but then, and then we don't know what's happening with Jonathan, the elder brother. And Jonathan, the mother keeps saying that Jonathan wants to go to Australia with her. We don't know why. There's nothing that we're very uncomfortable with that allegation because there's nothing in support of that allegation. The social welfare officer can't ascertain that sort of information. So the judge has decided on a Saturday morning to see the child inside her chambers in the courtroom, in the court building, but not inside the courtroom per se. It was very brief. The whole interview was, I think it lasted for like 10 minutes or something like that. It was recorded and we had the transcript. The transcript was just 2 to 3 pages. And the judge asked him what his wish was. He said he wants to go to Australia with the mother. He couldn't specify any reasons. That's all you get. And the judge would not probe too deeply, because the purpose is not to get evidence, but to actually hear it and see how it makes sense in the facts. Okay. Separate representation is also not automatic. It is very unlikely you would have separate representation of the child if the child's view is reflected and evidence before the court. And the separate the representative is usually a official solicitor who has no interest in the proceedings. The official solicitors would have a dual role in the proceedings. He will be an officer of the court investigating into the best interest of the child, but at the same time, he's also a solicitor acting for the interest of the child, to represent the child's view. So that also happens in Jonathan and Jaden's case. What the official solicitor had to do was to, firstly, she had a report. It documents her interview with the children, her phone calls with the teachers, psychologists, and parents. So in that sense, it is similar to a social investigation report. But the official solicitor is a legally trained person. She is a solicitor, and she would make legal submissions as well in representing the interest of the child. So they look at the facts just like, kind of like an investigator, just like the social welfare officer, but they also have the best interest of the child. They also represent the child. So, and on the other hand, the social welfare officer is neutral and biased. They don't represent anyone. They're just the agent of the court to get some evidence. Okay? But don't get too excited about wish of the child. In at least half of the cases, they are not being considered because the children are too young to be considered. Okay, physical, emotional, and educational needs. It depends on the child's age and sex. Because when the child is older, relatively, then he or she would have less physical needs, unlike a baby. But then, as they get older, education, parental guidance, and discipline would become more important. In MNH, what happened was that the father of the children died in a work accident in Hong Kong. At the time, the mother was living in China. The older child was seven months old, and the mother at the time was pregnant with the second child. So the mother left the boys in the care of their paternal grandparents in China. There was a court order from the PRC court giving the custody of the boys to the mother, but then the grandparents refused to allow contacts with between the children and the mother. And subsequently, the grandfather moved permanently to Hong Kong with the boys, and he refused to return the boys to the mother. So the mother issued proceedings in Hong Kong for the return of the children. And during the course of this litigation, apparently the elder son became extremely hostile to the mother, and the younger brother was highly influenced by his brother, so he also rejected the mother. In this case, an official solicitor was also appointed to represent the interest of the children, And somewhere in relation to the points of physical, emotional, and educational needs, somewhere in the evidence, the grandfather admitted that he did not see the benefit of the children to see their mother, who he thinks was irresponsible. He agreed that the children were under great pressure, but he saw nothing he could do to alleviate their stress except reducing the access frequently. So in paragraph 19.4, which I have included here, it is said that I wholly endorse those observations by Ms. Tam, that's the social investigation officer, and Ms. Tong, the child psychologist in this case, and share the grave reservation about the grandfather's ability to help the children to develop their emotional and psychological growth in the long run. There is no question that the grandparents have so far provided adequate care for the boys, but children do not just need physical care, especially when they grow older and require less care on the physical side, when emotional care, parental guidance, and discipline take over as more important and essential part of their growth and development. And it is in these important areas that the boys will unlikely receive if they are to remain under the care of their grandparents, who have selfishly, irresponsibly allowed their personal feud with their former daughter-in-law to involve the children, to the extent that they have directly or indirectly influenced them to say and do things that one would not allow to a stranger, let alone to their mother. Okay? I will do another slide on status quo and then give you a break. Okay? So, status quo refers to stability in a child's living environment, the physical environment, emotional bonds and relationship, the structure, or the caring structure, and also other existing relationships of a child. It is extremely vital, and if you are a parent, you would understand the needs to provide for stability for children. Because in a divorce, children are very smart. They can sense the tension and breakdown in their parents' relationship. So it's always more desirable to have the children live in the same house, surrounded by his own possession, in familiar environment and familiar routine. So you would want to, as far as possible, to keep the same school, the same schedule, the same extra curriculum, just the same as before the divorce. But it is difficult because when you divorce, you have a split of the household. And then because you have to see both parents, you have to take into account the schedule of traveling between the two parents and then splitting the time between the parents. The importance of status quo is reduced when the child has a close relationship with both parents. In these cases, the disruption caused as a result of change in family arrangement would be much less. So in LNC, the husband took the young child to live with his parents, the paternal grandparents, and 2 days later the mother took the child from the grandparents, so the husband took out an application asking for return of the child, which was then granted by the family court. But the decision was overturned on appeal. And it says by the Court of Appeal that the importance of the status quo would vary from case to case. In this case, it is merely some confirmation that the existing circumstances are not adversely affecting him. There is no reason to suspect that if the mother's proposal were to be accepted, any change would be adverse of itself, and hence the significance of the status quo is of very small importance. it is also said in Y&L that although it is clear that the issue of status quo is important, but it will need to be assessed on a case-by-case basis, depending on the individual circumstances of the case. Status quo will be more important in some cases than in others. What happened in Y&L is that there is a 8-year-old girl who was looked after mainly by the husband and the grandmother. The father wants to preserve the status quo and the mother wants to change. The status quo that the husband is seeking to preserve only lasted for 15 months, so slightly over a year. The grandmother, the husband's mother, was 74 years old, and there is no evidence to show that she was able to provide for care in going forward, especially given her age. The father was providing appropriate care for the girl, and upon the change of status quo, there is possibility that the wife might change the school for the girl, and the girl has to adapt to a new environment. So the husband wants, the father wants to preserve a status quo of 15 months long, and the mother might have to change the status quo for the girl. But the child has told the social welfare officer that she is ready to change the living and schooling environment and meet new friends. And the officer opines that a change in status quo in these circumstances is not a reason for not recommending custody to the mother. So in this case, even though there is a possibility that things will be changed if custody is given to the mother, but then it's not severe enough that would deny custody to the mother. Okay? So in the end, the judge was of the view that these potential changes are not insurmountable, and the advantages of having this new environment outweigh the disadvantages of having the status quo. So in the end, the mother was given custody with generous access to the father. Okay, these are just examples. You don't have to, for you to consider what status quo mean, you don't have to memorize these cases. Okay, 20 minutes. Come back at 8:45.